I recognize most of the faces in the room, but not all of them. For those who I've not yet met, my name is Michael Moffitt. I'm the Dean here at the University of Oregon School of Law, and it is my pleasure to introduce Senator Russ Feingold to all of you today. Introducing Senator Feingold is, well, you're here for the ADR talk. I don't need to introduce him in that sense, except I don't know if any of you have read a book called Father Joe by Tony Hendra. It's a book about a guy and his relationship, lifelong relationship with a monk who sort of served as an advisor to him throughout his life. And it's a touching story about life and life. It's a good book. And toward the end of the book, what you discover in this autobiographically told story is that you sort of read this story and think that this monk exists just for the purposes of Tony. He doesn't exist outside of Tony's life. And then it turns out you read that a bunch of very famous people also have spent their lives going to this monk and see this monk as central to their lives. And it occurred to me to mention this book partially because it's a good book and partially because there are a lot of different groups that could have gathered at lunch today who would treat Senator Feingold as one of theirs. Really, he said ours. An ADR community would think of the senator as one of ours because of his identification with the Arbitration Fairness Act in particular, a piece of legislation that was, in my estimation, the most important piece of federal legislation introduced in at least a decade on the topic of dispute resolution. Now it turns out we could be a group of campaign finance people, of healthcare people, of foreign trade people, of a number of different kinds of people, and we would think of him as our champion senator. But today, at least for the next 45 or 50 minutes, we get to treat him as ours for ADR purposes. The format for this is, I think it was advertised as I get to call him a senator and he doesn't get to pass, which is enormously attractive to me, but I don't think it will fully go that way. I have some questions, and at some point along the way, I will invite all of you to join me in asking the senator for his perceptions about, in particular, the Arbitration Fairness Act and dispute resolution, but we can go beyond that as well. The place I'd like to start, if we could, is not with the merits of the act or exactly what it was hoping to accomplish. I wonder if you remember the first time any of this even occurred to you. When did this get onto your radar screen at all?
Well, Dean, first, thank you for the kind words and for your congratulations on your elevation to Dean. And that's the first time I've ever been compared to a monk, which is terrific. I'm teaching at a Jesuit law school, and I gives me bona fides in that regard. But thank you for the kind words. You know, I actually can completely pinpoint when I became concerned about mandatory arbitration, which may seem a little wonky to you, but it just happened that way. I grew up believing that voluntary arbitration was a good thing. A former brother-in-law of mine, married my sister Nancy, is a well-known labor arbitrator. So, got along with him great. When I was 15, 16, he used to take me along to his arbitration sessions. So I loved it. I thought it was fascinating. I thought it was a great alternative that parties freely entered into it, or were of equal bargaining power, that this was a good thing. So I always, in my mind, not only regarded it as a good thing, but I knew a lot of the leading arbitrators in Madison and in the state and had a very high regard for it. So fast forward to 1993-94, I'm up in New York City for some reason, grab the New York Times, get on the shuttle, open the paper, and see that there is a story about young professional people, including women, African Americans, and others, having to sign an employment agreement before they went to work at a securities firm or even a law firm, excluding their right to challenge for sexual harassment or racial discrimination, that they wouldn't be allowed to go to court. But in advance of a dispute or a problem, they would have to agree to out-of-court mandatory arbitration. And was surprised. And basically that was the moment when this legislative effort, at least in the modern era, began because of that moment. And I introduced a bill that had to do just with that problem. Then I discovered that it was infecting everything else, mandatory arbitration. I found it in beef contracts for my, particularly out of Iowa and Wisconsin, for farmers being forced into this. And Chuck Grassley, Republican senator from Iowa, joined with me, and you know, there used to be bipartisan bills, remember those days? So we started to work on that. Then we got into the bankruptcy bill. And the credit card companies were pouring soft money into one of the most brutal pieces of legislation ever. A woman named Elizabeth Warren came and explained to me the problems with this, who I hope will be a senator before long. And one of the things I discovered and tried to do something about was, you get your MasterCard, you sign up for a credit card, you get this pile of junk that comes in the file. Well, one of the things that's in there is you agree to mandatory arbitration too. But the thing that put it over the top was completely surprising, and we succeeded. And this was where the car dealers came to see. Now, the car dealers were not my friends generally, not because they were really hostile and I'm perfectly happy to buy cars from them, but they were basically all Republicans. And we'd have the meeting every year. We'd sit down, we'd talk about their issues. No, can't help you on that, can't help you on that. And finally, one of them said to me, we are sick and tired of these big motor companies making us sign mandatory arbitration agreements with regard to our franchise. And I said, well, that's interesting. I'd be happy to help you. And they were surprised. Well, I went back to Congress and found out that a lot of the senators in those days, even the very conservative ones from the South, in those days they were closer to their local Republican car dealers than they were to the big corporations. That's no longer true. But it was them. And they were afraid. A guy like Jeff Sessions of Alabama was fighting. He agreed with me. Warren Hatch agreed with me. And we actually beat them. And it was the only time, I believe, that legislation was passed, and correct me if I'm wrong on this, but that actually prohibited mandatory arbitration agreements in this area. So, kept running into all these circumstances, and finally, you know, I had the opportunity to author the overall bill that essentially says, you know, yeah, mandatory arbitration is fine if you agree to it after the dispute has arisen, but not before. And so that's where the bill came from, and now Al Franken, I think, is taking the lead on it. But I agree with the Dean, this is not just any issue. It sounds arcane, sounds like just a side issue. It is a huge issue because it basically denies the right to go to court. It's the foundation of our legal system if it's abused. So I think it's a big, that's how I got involved with it.
Tell me more, if you could, about why it is that labor arbitration feels so different
than the other kinds?
Than the mandatory, than the consumer or employment kinds of arbitration that the AFA targets.
Labor arbitration is based on a principle of, long-standing principle of trying to balance two relatively powerful institutions in a way that they can come together on an agreed basis that they understand to collectively bargain or make their agreements in contracts that have some stability over time. This has nothing to do with what a individual beef farmer, an individual consumer who's in college for the first time gets their letter from the credit card companies, how would you like a credit card? I'm not saying that they're absolutely equal relationships, but they're institutional relationships in which that kind of thing mutually agreed upon over time makes some sense. This is simply inflicted on people who have no idea what they're getting into, or in the case of car dealers, where there's just no choice.
So it's adhesion contract settings as opposed to a labor contract where everything's on the table.
That would be a term that would make sense to me in that context, yeah.
Can you imagine circumstances in which you would see pre-dispute arbitration agreements meeting that standard outside of labor?
There could be some, but I have not thought of many, and I did not feel the need to accommodate those. But as we were working on the legislation, if somebody made a credible case, there's a possibility of exception. But the general principle should be, and the law should be no, in order to avoid this exploitation. I understand I read one of your students who did a history of this subject.
Hal's not here.
He wanted to be.
He wanted.
Would you tell him I enjoyed it? And even though he was objective, I liked the way he wrote it. And I felt that, you know, anybody reading that knows that this, in my view, is one of the biggest scams of all time. You pass a bill trying to encourage arbitration, and somehow the corporations in the country figure out a way to turn it in a way that you can't go to court. I think his paper effectively demonstrates the history in a way that makes it possible for a less objective person to conclude that something really, really bad has happened here to protect people's rights in so many settings.
For those of you who have not read Hal Neth's paper, he was a 3L last year, wrote his, that thing we make you write in order to get out of here. He wrote his paper. He was a joint degree student, JD, and a master's program on essentially a history of the Federal Arbitration Act. And in particular, its interpretation by the Supreme Court in recent decades, which has caused a re-articulation of preemption doctrines in a way that, to my mind, has created, wholly aside from the policy arguments related to arbitration clauses, where I think the Senator and I probably agree in great measure. One of the things that the Supreme Court's preemption doctrine, as it has evolved, has done is has essentially read the Federal Arbitration Act to preclude states from declaring, as a matter of state contract law, how contracts, including arbitration clauses, are to be interpreted. One could imagine, absent that Supreme Court line of cases on the preemption doctrine, one could imagine that some states, hypothetically, California, Oregon, Montana, those aren't actually hypotheticals, those are states that have tried this, could say, well, as a matter of state contract law, this stuff will be enforceable, this won't, this will only be enforceable if. That's bread and butter contract law. For those of you who are 1Ls, you're suffering through this right now. You know that, as to most things in contract law, states get to decide what makes a contract enforceable or not, what makes a contract unconscionable or not, what the remedies might be. That's just states to decide, unless, as the Supreme Court has interpreted it, unless the clause has something to do with arbitration, in which case the Federal Arbitration Act presently is deemed to preempt those state laws to the contrary. And so what we cannot see right now is states stepping into the gap that you're describing, Senator.
By the way, this whole issue of preemption is something that I've struggled with. I struggled with as a legislator for many years, but particularly as a state senator in Wisconsin for 10 years. I was, new state senator passing the first laws I ever ever been associated with. And in two cases right away, Reagan had just become president, I ran into this problem. I wanted to pass a bill to make sure companies kept track of the hazardous substances they used for long periods of time instead of destroying the records. Passed it as a state law, but it got preempted at the federal level. And, look, there are areas where obviously I believe in preemption. Certain areas of environmental law and others where you have to have a national policy to make sure that policy is a national one, because waters and air and so on do not respect state lines. But there are other areas that are classical state law area. And, Wisconsin, we take great pride in having been one of the great states to experiment with progressive ideas, and the federal government wasn't able to stop them. The first child labor laws, first unemployment compensation system, and yes, the first public employee collective bargaining until this year. And so this issue, in the context of this subject, but also in many other contexts, is a real damaging thing for our system of government, because we still need the creativity and flexibility of states to do things on their own, and this is an area that should not be preempted by massive corporate interests that dominate the show.
Wouldn't the AFA maintain the federal preemption, just change which the preemption is? That is, Wisconsin still couldn't do anything different as to arbitration,
yes,
if the AFA were passed, right?
Well, this is an attempt to create a federal policy against mandatory arbitration of free dispute. Yes. In other words, I certainly agree that there are certain things that are national. I believe that these are inherently unfair and should be prohibited nationally. I do not think it should be state by state. And I am a progressive, so my attitude about state laws is they should generally give people the chance to do more, where government can do more to protect people, but no, I don't think that they should be able to go below a fundamental protection of individual rights and protection of a right such as going to court. To me, states have no right to pass a law saying that you can be asked to agree in advance in the case of racial discrimination, to sign an agreement that says you can't go to court if later on they racially discriminate you against work.
When the AFA failed to pass, I know there were proposals to do essentially carve-outs,
yep,
as you were describing. That is, to propose, well, maybe what we should do is credit card loans, or maybe what we should do is, and so identify an industry and just go after that. And I wonder, in retrospect, what you think about that.
Well, that's how I got involved in the subject. That's how it began for me, was seeing certain contexts where I thought it was particularly wrong. And I also believe that the way to get the overall ban was to create a constituency by pointing out areas where people could understand it. The farmers in Iowa and Wisconsin get it, and the car dealers get it. And in fact, one of the most interesting little things about that car dealer thing was, guess who had mandatory arbitration agreements with their customers at the car dealership? Car dealer! And I said, guys, no. They had a huge fight about it. And I finally forced them to not make their own people that buy cars sign mandatory arbitration. So my answer to you is, this is a way politically to bind together coalitions where people feel like, you know, I'm an anti-mandatory arbitration guy. And so it isn't the best way necessarily, but it's very hard, as you know from the way you're articulating this. It's very hard to get people excited about mandatory arbitration bans. You know, it's like, what are you talking about? But if you point out to them they're getting ripped off when they get their MasterCard and so on, and people, yeah, and so it's a very difficult thing to get done, but I think the political strategy does include targeted attempts to ban certain ones and then ultimately banning it all.
What would the political conditions, what's your guess about the political conditions that would need to exist for the AFA to be passed next session?
That would be tough. I had a hard time with Democrats on the judiciary committee. We would have gotten somewhere with this, but you know, there are some very powerful interests that support Democrats as well, or more, that don't want this. I mean, where did I first discover this? Wall Street, security firms. They gave more to Obama than they did to McCain. So, you know, this is why I think the Occupy Wall Street people are on the right track, is that you have to confront this power of corporate America to get its way from either party or from both parties. And I can hope that the next election will change all of this, but, you know, I think it needs to be a long-term effort to get commitments from individual senators and congressmen to support the legislation. And, you know, there's powerful support on this side. I mean, the trial lawyers of America feel very strongly, perhaps, and certainly partly self-interested, of course. I don't deny that. The thing that's nice for me about the issue is I didn't even know the trial lawyers cared about it until I was deeply involved in it. All of a sudden I found out it was their #1 priority. You know, I get along very well with a lot of trial lawyers. I think they play an important role in our society that is too often denigrated. But, you know, I'm hoping that the combination of forces that support candidates that are running this time on the progressive side, the Democratic side, or even Republicans can get commitments from people that support the law.
You raised the securities context. That is one of the only other contexts where there is, from an arbitration perspective, an existing mechanism that creates anything other than the Wild West version of mandatory arbitration, right? Because there, the SEC and Sarbanes-Oxley actually have something to say about securities disputes. I think there are some things one might reasonably say in critique of securities arbitration, but I think it might represent something different than credit cards and franchises and things like that. Even though it is not an example of an entire ban, it's just it's a regulated rather than a banned.
I mean, those kinds of alternatives, I think, should be examined on an individual basis, make their case, instead of the United States Supreme Court saying, oh no, you can't affect these mandatory arbitration agreements, they're fine. So, you know, you pass an overall ban, and if there is a legitimate alternative that the various parties agree to, you can think about it. But, you know, my concern is always, who are the parties to the case? What resources do they have? Who chooses the arbitrators? One thing I ran into a lot was the you know, unfortunate coziness between those who represent the industry's side and the arbitrators that tend to get picked and make their career out of this. I mean, that's a natural thing that people that tend to hang out with and go to conferences and things with people where, you know, in theory, they're going to try to be unbiased, but the truth is they become co-opted psychologically, at least, by those with whom they see a lot. And so one of the questions I would ask is whether that sort of phenomenon and arbitration would be on both sides of the table, or is it on one side of the table? I guarantee you, when it's people like credit card people and beef farmers, you know, these are not the people that these people that make a career out of being arbitrators tend to know as well. They tend to be more associated with the industry people, because that's what I understand.
I want to preview to you that shortly I'm going to say any questions, and that's, you know, so this is the time when you can be prepared to avoid eye contact with me, or whatever your strategy will be for not getting
called. Do you use the Socratic method here at Moscow?
When it's needed.
I spent some time in my law school class the other day reading Catherine McKinnon's feminist critique of the Socratic method.
Yeah.
There was some cheering as I used the Socratic method.
I think my understanding is she did as well, but that's from outside of the ADR community, I know that there are many, at least inside the ADR community, for whom it is challenging and frustrating to have arbitration lumped together with other purely consensual forms of dispute resolution. And I wonder, as someone who doesn't spend all of his time thinking about ADR sorts of things, the way some of us do, I wonder what your reactions are to the notion of ADR and all of settlement being characterized in the same way as mandatory arbitration.
It's completely unfair, totally unjustified. You notice I began my remarks by telling you how I've always felt about alternative dispute resolution. It may make perfect sense in many cases, and I think it's necessary to have that kind of a alternative available. The way I look at it is, people have destroyed the reputation, or tried to, had the effect by overreaching and using the good principles of voluntary arbitration as they've taken the positive association with that to justify something that's unjustified. And so I would urge people within the ADR community, which I didn't even know was a community.
Oh, we're a community.
Until
a lot of things.
Until I was pressed into service at Marquette Law School by a former colleague of yours who said, you need to come to the ADR. I said, I'm not an ADR professor, but you've been involved in a lot of disputes, right? And I said, well, yes. So that'll be fine. It's completely unfair. But it's not the responsibility of those of us who are trying to remove the cancer from arbitration to be nice about the corporate fantasy that this represents. It's the responsibility of those who care about voluntary arbitration to fight for it and to make that distinction, which I think people like me should help with. But there's no justification for treating them the same. If people agree to voluntarily in advance of a dispute to go by that route, as long as there are reasonable rules and ethical standards, which I've seen in operation, then it should be encouraged. But I can understand the frustration, because it really isn't fair. Time-honored approach to solving problems.
One more question before we go see what other folks want to hear about. The Senator was sharing with me on the way in the room about his law school experience. And it turns out we had the same civil procedure professor.
Who believed in the Socratic method to the point where he was basically Darth Vader.
He had a very particular energy.
Yeah, there's a diplomatic way.
On the topic of civil procedure, one of the developments recently in arbitration has to do with the question of class-wide or collective litigation or arbitration. There are a great number of kinds of disputes for which the prospect of individualized litigation is an economic fantasy, even if it is a procedural availability. And for at least some time, it was possible to see class-wide arbitrations as a vehicle for redressing the sorts of disputes for which class actions were designed, at least monetary class actions, right? The mass fraud of a tiny amount on 1 million people. Turns out no one of those individual consumers has the economic incentive to bring that action, and yet we would want that action to be brought in the abstract as a society. If we enforce arbitration clauses, mandatory pre-dispute arbitration clauses, if that is step one, then we no longer have class actions, at least Rule 23 sorts of class actions. So then the question becomes, well, could we do that in arbitration? Could we see collective adjudication through an arbitrator of these mass consumer frauds, for example? And for a while, the answer was yes. As a practical matter, because of more recent developments, in a, I'm at risk of sounding more partisan than is typically, well, here it is. In a judicial opinion requiring considerable mental gymnastics, the court, in defense of individual liberty, decided, well, no, essentially, one could not possibly force these consumers who didn't choose class arbitration to go into a class arbitration. And so there is, at least in many contexts, this vacuum now where precisely the kinds of small dollar, large number of victim frauds, for example, there's functionally very little opportunity that any corporation with a competent lawyer will face class actions or class arbitrations. One could imagine that being another avenue in, even if you couldn't get the entire that in particular would, I think, provide an opportunity for a legislative fix. I'm not positive.
I think that, I mean, the reality is it's going to be very difficult to pass the overall bill in the near term. If the signal is sent that, at least solving this problem legislatively, could possibly avert that, not that I'm recommending that, but that is one thing for a skillful legislator who wants to solve that particular problem might use that technique. For me, there's so many other contexts that need to be addressed that I think to take the wind out of the sails of the overall movement, but I don't disagree with the possibility of a legislative fix there.
Part of the challenge is that arbitration, unlike litigation, at least in some contexts, is more easily navigable by pro se complainants.
Right. Oh, it can be. And
that's a to take that away, so there is a real, I think, I'm going to do a law school professor trick, which is now having declared myself to have asked my last question 2 or 3 questions ago. I'm going to ask my last question now.
It's not just a law professor trick.
Your trick is just answering whatever question you wish I would have asked.
Exactly. There we go.
Virtually any piece of legislation or policy represents some trade-off in policy ideals. You're trading this over that, you're valuing this more than the other, you're placing this bet as opposed to that bet. How would you characterize the policy trade-off represented by the AFA?
Well, there is a trade-off, and the trade-off is that if a system of pre-dispute mandatory arbitration could really be a fair system, if it really did accommodate the wrongs that occur in a way that would be affordable and fair and accessible to people, in theory, there are advantages to that. Like I saw that there were a couple articles here that were suggested to students that they could read on this subject, and one of them was a guy who was against the bill, basically calling it a monstrosity, but laying out, various perfectly logical, practical things that are true sometimes about not having to go to court. Going to court isn't always a, bowl of cherries. So there is a trade-off there. There are trade-offs of efficiency. There may be trade-offs for the people that are wronged if there's a better way to do it through pre-dispute mandatory arbitration. So that would be a way to characterize. To me, just use of justice and rights override that. The notion that somebody can be asked to give up their right to have a wrong addressed before they've even experienced the wrong goes against my fundamental ideas of justice. And I don't think people can know, to say, yeah, I'll sign this thing that says that if I'm sexually harassed at work, that I'll go to an arbitrator. That sounds fine. I'm taking this job. Then all of a sudden they experience sexual harassment. And it feels a little different. That's why I can't go with those arguments. But there is a logical and reasonable debate that can be had. It's a legitimate public policy debate, but I obviously have strong feelings about one side. All right.
It's not that I'm out of questions. It's that I'm going to now invite you to ask questions if you have one. Chris?
Yeah, I'm Senator Feingold. I'm interested in your perspective, your unique perspective as an elected official. You were talking earlier about the political climate that's necessary for the AFA to get passed. And I feel like right now, especially, I think there's a greater awareness, and it's a fundamental sense that, yes, corporations do have an unfair advantage, and obviously the Occupy Wall Street movement is kind of centered around that. So in your perspective as an elected official, maybe you could tell me from experience, at what point do elected officials, like, where's the tipping point where there's public opinion versus corporate funders to your campaigns, et cetera? Like, at what point do you say, okay, I'm sorry, I can't do, the corporation's still saying, no, you have to, forget this issue, it's a non-issue. At what point do you say, the public opinion is too strong, I can't ignore this anymore?
Well, this has to do with the politician's view of how they're going to win an election. Okay? If they believe that people aren't going to pay attention to particular votes or how they vote, it's just making sure you tear up your opponent or raise enough money and you're elected, they're not only are they not going to worry about the public's sort of in theory view about something like this, they're going to seek the money of the powerful interests that want this. That's the typical political figure that would do that. Now, if they think that something is really taking hold with the public that could actually cost them votes, then they start worrying about whether or not it's worth it to take the money in order to take the chance that they're going to get hung out to dry for siding with these interests. Sadly, in recent years, it seems like there's so much obfuscation and so much personal attacks that it's very hard to make a politician pay for having sided with the corporations. And so, yeah, you get a guy like Conrad Burns out in Montana. He was rolling to re-election. He couldn't have been in bed with more corporate interests if his life depended on it. I don't care if you're recording this. The reason he went down is he got associated with the Abramoff scam. So it really wasn't that the people of Montana figured out that Conrad was spending far more time with lobbyists than he was with the people of Montana. It's that all of a sudden it was sort of embarrassing. But that's the lesson that John McCain and I learned on campaign finance. We found out that, when one of those exposés goes on TV of the senators playing tennis for, $250,000 at some conference comes out, or one of those things comes out, it's sort of the shame factor, the embarrassment factor. I would say that up until now. Now I'm beginning to wonder if that even works. The things that people will let people off the hook for now?
For the record, the dean will play tennis for far less.
So it's a calculation, but the tendency now is for political advisors to say, it'll be a 5-minute story or a 10-minute story. That a particular vote on arbitration, that's not an easy thing to run a 30-second ad, either for or against. So, when Wayne Morris was around, being associated with the big corporations and so on, that was something you could really take to your opponent. Now it's more difficult, but as you say, there may be a change coming. And if this Occupy movement can help make that change and make politicians think twice before they side with corporations all the time, that would be a wonderful thing.
Others?
Yeah. You mentioned earlier that there used to be bipartisan legislation, and you were well known for crafting that across the aisle. In your opinion, what happened and what needs to change for that to return?
It's a relatively recent development. In Wisconsin, it was highly valued if you were known as a person that worked on a bipartisan basis throughout the 50s and 60s and 70s. I actually found more opportunities for bipartisan work in the U.S. Senate than I did in the State Senate. The State Senate still had rules that were, more partisan in nature because everything was by majority vote. But in the U.S. Senate, with the need to get 60 votes, the need for bipartisanship was structurally even greater. And so I found that the people in the Senate that you could really admire and like were those who would work on a bipartisan basis. People like Mark Hatfield, who was closest name to a saint as a person. I mean, the guy was a wonderful person to work with, Senator from Oregon. Very willing to work on a bipartisan basis. Senator from Rhode Island, John Chafee, and his son then Lincoln Chafee was a senator later. He's now an independent governor of Rhode Island. This was sort of these were the people that were kind of held up, and they were the power brokers, because if you are somebody that's willing to work with the other side on stuff that is hopefully admirable, you hold you're the swing vote. So then when McCain and I got together, and that was the most unlikely of combinations. I mean, not only was I came to the United States Senate in 1992. I was the youngest member of the Senate at age 39. I continued to be the youngest member for many years, and the lowest in seniority. In fact, I'm still under the average age. It's like 63. I was the last man on totem pole in the back of the chamber, and the only reason I got to move my seat was because Ron Wyden came to the Senate. So I was the last man, although we were in the majority. We get the majority. We lose the majority in 1994. All of a sudden, a phone call comes in from John McCain. I go, why? The guy just growled at me the other times he'd seen me in previous two. But he said, you know, now I was dead last because the Republicans had the majority. And he just said, you know, I noticed you're good on deficit issues and reform issues. Do you want to work with me? It was a revolving door issue. Members of Congress, staff members going over to K Street, and I said, well, let's work on the gift ban. We didn't start working on campaign finance until a few months later. So I go to my town meetings in Wisconsin. I went to every county every year, 72 counties a year. So I did 1,300 town meetings and was accused of not listening. I go to the town meeting and I go, you know, this is a town meeting. I only got to talk for a minute. You're going to talk to me. But let me just tell you, I'm doing this bill with John McCain. Hey, you know. He said, you don't even know what's in the bill. That could be a bill to ban dairy farming. They didn't care. They were so darn glad that a Republican and a Democrat were working together that meant the world to me. How did it change? You know, the Senate went on television, and I'm not saying I'm against it. I'm not. The Senate went on television, and people could see us being friendly with the other side. Senators would give a speech, and if they didn't give the red meat to the very extreme elements on either side, how come you're not stronger on it? So that began. Then the cable TV phenomenon, Fox News, but also MSNBC. All of a sudden, they have the capacity, which in the long run I think is a good thing. But in the short run, there's a nominee, and they can do this attack on a person, saying, you know, if you vote for this person, you're doing this awful thing, and no Republican should vote for this person, or no Democrat should vote. So the polarization and the ability to yank people away from each other out of the fear of the electorate, a different kind of fear, has immobilized many members of Congress who still have really basically very cordial relations. You know, what's it like? You guys fight? No, they're not. It's polite. Nothing's happening. They can't get anything done, but it's not like looking at Fox News or MSNBC or people screaming at each other. It's just that everybody's paralyzed by the fear that they're going to get in trouble for cooperating with the other side. A great example is Lindsey Graham trying to work with John Kerry on climate change. They started passing resolutions in South Carolina, Republican Party counties, censuring him for trying to work with John Kerry on climate change. A moderate, sort of as a compromise kind of bill. So it has been seriously compromised. And the only thing that will change it is a demand that by people that we want to know, you demand of your legislators, who are you working with on the other side? Show me that you have made the effort to do that, and it can come back. But right now, those who don't want people working together have the greatest voice.
Ellen?
One of the amazing things to me on the arbitration issue is that while lots of countries around the world have arbitration, it seems that the U.S. is pretty much standing alone in terms of having arbitration, mandatory arbitration in consumer and employment setting. Does that matter at all? Does that, or how does that play politically? Does that make it more likely, less likely, or is it irrelevant to?
The fact that it goes on does not happen in other countries?
The fact that the U.S. is really alone in having this kind of arbitration. I mean, we don't have the protections for our consumers and our employees that exist in other parts of the world.
Arguments about the rest of the world don't go very far right now, and, you know, unfortunately, because it's sort of mindless not to think about what 180 other countries do and sort of see, got a better idea. That doesn't go very far. What can affect it, though, is, you know, frankly, the world, the international nature of the economy. And the fact that companies and others that don't engage in certain unfair practices maybe can get a better reputation and seep back in the United States, but that may be awfully idealistic, but it's one of the, I'm very skeptical about and disappointed about the results of so-called globalization. I opposed all of the trade agreements that were pushed by both parties. But there may be, in the long run, some benefit from the fact that companies operate in other countries and can't do certain things in other countries, and maybe they will adopt that as part of their policy within the United States, too. I wouldn't hold your breath. Tim?
So I'm guessing it's hard to predict if your legislation passes what change there will be in the volume of cases that stay in arbitration or alternatively go the litigation route. Yeah, we don't know how many consumers will choose to say, well, even though I understand the situation, I'm going to choose arbitration. But so that aside, that question aside, it's been amazing to me to watch how the courts, Supreme and lower, have the decisions they've been making around arbitration. And in trying to understand their logic, it seems that one big piece must be the fear of what will happen if the courts begin to say in any kind of significant way that arbitration rulings can be reversed in court. For the most part, they are not. If they do start doing that, then this edifice begins to collapse. And you know, this arbitration piece is not separate, it's tied into the web. What happens then when arbitration in the form that it's in now, creating the volume of arbitration cases that are now created, what happens when and I support your effort, but what happens if that effort is successful?
You're talking about courts taking a look at the results of binding arbitration and reversing them? Well, obviously, if that becomes a standard practice, it will destroy the meaning and the value of binding arbitration. The goal should be that people voluntarily choose to go into arbitration and that it has some finality. That's the whole idea behind it.
But then how will we cope at the court? Because part of at least as I understand it, part of the reason arbitration has grown to the dimensions it has is that we've said, not just that it's quicker and faster and, you know, but it also has relieved the pressure on courts that were, you know, having a hard time putting it up. We're going to have to come back to that question.
Well, I think passing the bill that I proposed in the past, that Senator Franklin's proposing, holds out the prospect of relieving the burden on the courts as well, because the inherent unfairness of it is eliminated. People go into this kind of a arbitration with their eyes open, and I think are less likely to want to litigate the result, because there will be not only law, but a culture of accepting the consequences and not seeing this as a rigged game. And I think ultimately the result is that the courts will not be as affected by it if it's a fairly run system that people respect, as opposed to something that's bought and paid for. So I think doing this right can avoid the problem of the courts being besieged by this. It should do that.
Other questions? Yeah.
Just stemming off of the role of the judiciary in arbitration. So I read the articles and then some of the dissertation, but do you see the courts backing away from their previous judgments and moving towards harsher judgments on mandatory arbitration? Do you see continued consequences? Do you see a change, I suppose, in the judiciary?
Well, I haven't had a chance to carefully review where the cases are going. My sense is that the court decisions have not been good and that they have been unsympathetic to the inherent unfairness of this, and that's why this legislation needs to be passed and signed. And because I'm not optimistic about where the courts will go on this. They're way too pro-business these days. They need specific instruction from Congress and President. But I am not up to date on
I've read them
litigation
a lot. And I think that's probably, as a predictive matter, I think it is unlikely that you will see this judicially changed in any significant way in the near term. I think what you have at the moment is a combination of factors that make that unlikely. Even putting aside the partisan question, there is a particular strand of a preemption, to come back to that removes most of the interesting questions from even being in game. And now you have several decades of stare decisis. So that even some of the Supreme Court justices who previously have expressed sympathy with a different reading of the FAA have come out and said, actually, you know what, I've been saying this for a while, I'm apparently wrong, I give up. Congress can always fix this. I think we're essentially in a Congress can always fix this. You tell us if we get it wrong holding pattern in the Supreme Court. And I don't think that lower courts are likely to go. The Supreme Court has been fairly unambiguous at this stage in its articulations. I don't think there are a bunch of circuit opportunities for re-examination. I think that with the preemption doctrine the way it is, most state Supreme Courts, all but the most entrepreneurial state Supreme Courts, have treated this as a done deal as well. And so I think it's probably unlikely to come out of the judiciary at this point. I am at great risk of making this go beyond the time when we will be invaded by a bunch of nervous law students who need this space for their next class. I hope that you will join me in thanking the Senator for coming.